Hey, Paul Rabley here. I want to talk about United States savings bonds as it relates to estate planning in Louisiana. So I'm Paul Rabley. I'm an estate planning attorney here in Louisiana, helping people all across the state arrange their legal affairs so that it goes exactly how they want it to go. And then when they pass away, we help make sure all that estate settlement is simple. So a lot of people come into our office when they're getting their legal affairs in order with a stack of United States savings bonds. And we see that a lot. They don't know what to do with them. And they don't know what's going to happen when they pass away. And the other scenario that we see a lot is when the surviving family member comes in the office after a parent or loved one has passed away, and they bring in a stack of United States savings bonds that were in the name of the deceased family member. So the purpose of this video is to really, give you that kind of Louisiana specific way to handle United States savings bonds. All right. The first thing I want to go over is all of those things that make Louisiana unique and apply when somebody dies and they own different things. Whether it's, the community property laws or the forced heirship laws or the Napoleonic Code or the usufruct and naked ownership, or the fact that Louisiana doesn't recognize certain forms of ownership like joint tenants with rights of survivorship. Well, when it comes to United States savings bonds, you can throw all that out the window because we do what everybody else does when it comes to U.S. savings bonds. They have their own set of rules and we follow those. So I first want to talk about what happens or how U.S. savings bonds are registered or titled for an adult and what all that means, particularly when they pass away. So 3 scenarios on registering U.S. savings bonds for adults. The first one owner. Could be a paper bond, could be an electronic form. You got one owner. That owner is the only person who can transact it. And when that one single owner dies, the savings bond is in their estate. So, got to go through probate, got to get an executor confirmed, an administrator appointed, got to go through the normal channels of probate or succession to get access or cash in the savings bonds. The second scenario is where you have an owner and you have a beneficiary on a U.S. savings bond. Again, owner is the only one who can transact it. When the owner dies, it's payable to the beneficiary. They let you set up, electronic accounts that way. However, if it's a paper bond, then you're likely going to see on the paper bond the name of the owner and then POD, payable on death, to the beneficiary. So that's a second kind of way adults can register their U.S. savings bonds. The third way is when there's 2 owners. And if it's an electronic version, then it's going to be person A with person B, and only person A can transact the bond, but person A can give person B authority to transact the bond. And then if it's a paper bond, it's just going to have both names on there. Under either scenario, when there's 2 owners listed, when one owner dies, ownership automatically goes to that surviving owner. Doesn't matter who's listed first or second. And so that's really different from our traditional community property rules. So be aware of that. Now, the other relevant point, and we could go on all day for savings bonds, but one worth mentioning on this video is, how trusts get impacted with U.S. savings bonds. So some people who own U.S. savings bonds, they want to get those savings bonds out of their name. Either they want to get it into a trust so that none of that has to go through probate when they die, or maybe they want to get those savings bonds titled in the name of a trust for some type of asset protection type purpose. So there's a form that I printed off. It's the request to reissue United States savings bonds to a personal trust. It's called FS Form 1851, and it was revised in January of 2018. So this is what you have to use when you want to transfer bonds that are in an individual or in 2 people's individual names into a trust. All the parties have to sign off on the paperwork, send the bonds in. They don't reissue any paper bonds in the name of a trust. All that's done now electronically through accounts with what's called Treasury Direct. So you list the bonds and you fill out the other information that's requested. And then if that trust is a grantor trust, there is no tax consequence to simply retitling the bonds into the name of a trust. That interest will continue to accumulate and tax will continue to be deferred on that. So a lot of people want to retitle their bonds into a trust. There you go right there. That's important if you're wanting to avoid having to go through probate or maybe get them out of your name for future Medicaid eligibility purposes. Timing's real important to that, so you want to do that ahead of time. So there you have it. Main point here, all of those Louisiana community property, forced heirship, usufruct, throw it out the window with savings bonds. How savings bonds are titled becomes really important. And then whether those assets are in an individual's name when the individual dies or whether they're in the name of a trust becomes real important for a lot of different reasons. So hope that helps. The government actually has a pretty good website that explains all of this stuff. Let's see, I think I've got it up, treasurydirect.gov. That would be the place to go to find out more. I'm Paul Rabelais. Have a good day.